This is
I am so tired of living in unprecedented times.
I know. Give me those precedented times, right? They were great.
Please. Hello, team, and welcome to Beerocracy. I'm your host, Emily Gross, and I'm very excited today because I have Chris Mirasola with me, who's assistant professor at University of Houston Law Center, and we're going to be talking all about the National Guard and what my opinion is, slow, maybe fast ascent into martial law. But that's up for debate. So,
here we go.
Let's do this shit.
Thanks for having me.
Thank you so much for being here.
Yeah, I appreciate
Before we begin, what are we drinking? This is being recorded in the morning.
It is being recorded in the morning, so I'm having more coffee. I have 2 young kids, and so we need just gallons of coffee.
So I truly need like an IV drip.
Indeed.
And I also have coffee.
Amazing.
I don't want to toot my own horn, but I make my own pumpkin spice syrup.
This is very impressive. I have really terrible coffee from the staff room down the hallway.
No.
I know.
No.
Because I know. We need something nicer.
Yeah, you guys need the good stuff. But anyways, cheers.
Cheers.
So the question I always love to ask my guests is, why should we trust what you have to say?
Fantastic. Great question. So, my research is on domestic military deployments. So I've explored this area of law in a few law review articles. And before I was a professor, I was an attorney at the Defense Department's General Counsel Office, where the main part of my portfolio was domestic military deployments. That was like the last 2 years of the first Trump administration and the first 2 years of the Biden administration.
Okay. I truly can't think of anyone better to have on this than you. Okay. Initial thoughts. How are we feeling?
It's really interesting, right? So, two things. One, a bit lighter, darkly funny maybe, and then something more substantive. So my usual joke is, events over the past 9 months are great for my tenure package and terrible for the Republic. So
happy to help.
There you go. I appreciate it. More substantively, at the beginning of the administration, there were this whole slew of executive orders, right, where the president kind of laid out a whole bunch of different legal theories for using the military for immigration-related matters. And they ranged from things that we've seen before to things that were pretty extraordinary, things like the Alien Enemy Act and potential invocations of the Insurrection Act. And I kind of thought of all of these as existing on like a spectrum, like an escalation trajectory, right? And the big question I had at the time was how quickly we were going to go from, things we have seen before to, some pretty unprecedented events. And we've moved quickly, right? Like it took us 9 months to get to public discussions of the Insurrection Act. So not well is the short answer. Yeah, that's right. It's full term, and we're not even halfway through the actual term. Right?
Literally. So I had Harold Hongucho on a couple months ago talking about when first National Guard into Los Angeles, right? Because that was kind of the precursor. And so that's a great conversation. People should go listen to it if you guys want like a really kind of basic knowledge of what's going on. So I want this to be a little bit more talking about Insurrection Act. And then I don't know if you saw Stephen Miller's little moment on CNN.
Yeah.
Plenary authority. So let's dive in. So we're discussing the Insurrection Act.
Great. Good.
Yeah. What? Let's dive in.
Dive in. Fantastic. So the Insurrection Act, we kind of talk about as being one thing. Really, it's a number of statutes that are enacted from the end of the 1700s to like the middle-ish of the 1800s. That time frame matters because like it's important for folks to, I think, appreciate how old these statutes are, right? The terms that they're using are not the terms we would use today, and they're incredibly broad. So what these statutes do is they authorize the president to use the military to suppress insurrections, riots, obstructions to federal authority in a couple of different circumstances. So one is at the request of a state or territorial government, right? So like there's some kind of, Rodney King-esque riot, the state can't control it, they ask for federal assistance, and the president decides whether to provide it. That's less controversial than these next two that I'm going to be talking about. There's another provision that allows the president to independently decide that there's an obstruction of federal law and that the military must be used to kind of reinforce federal authority, right? It does not require a request from a state or territory. It's done by the president's own volition. And then there's a third category where individual rights, a la the 14th Amendment, are being violated. And the president believes that to protect those rights, the military must be used. So right now, our discussions are kind of about that middle statute, right? The one where the president decides that there is a obstruction of federal law that would require the use of the military to suppress that obstruction.
So for people that, just quick thing. So he's gone in under Title 1246 of U.S. Code 10.
Yes.
I know this because I just made a video on it. And that's the only reason why it's, because you're like, why on earth would you know this? And
it's
so,
great stuff.
So that's what it's gone into. But the Insurrection Act allows the National Guard, because right now the National Guard can only protect like federal agents and federal buildings. But the Insurrection Act allows them to like actually be a militarized police force.
Yeah, fantastic, right? Yeah, so there are a couple of differences, right, between what we're currently seeing and what would be authorized under an Insurrection Act deployment. So, to start with the current situation, right? So you're totally right? Section 12406 of Title 10 is what we often call like a mobilization authority, right? It is the authority for putting the National Guard member onto federal duty, right? Because folks have to remember these National Guard personnel on any given Friday, for example, the day that we're recording, are civilians. And so you need some mechanism for making them into a soldier. And Section 12406 is the mechanism for making them into a soldier.
It's crazy. Just like push a button and you're just like, hey,
exactly.
You're a soldier
That's
now.
Right. You're a soldier now, right? That's right. And then the authorization for the mission that they're doing, right? This federal protective mission that you were just talking about, right? That is based on a theory of inherent presidential constitutional authority. And in executive branch documents, it's often referred to as the protective power. It's a theory that's been around for a long time, even though I think it's pretty untethered from the Constitution's text. But what's important for the purpose of this kind of question is that it's limited, right, to the protection of federal property, federal personnel, and federal functions, right? And it is not an exception to the Posse Comitatus Act, which is the criminal statute which generally prohibits using the military for law enforcement purposes. So that's the legal regime that we're currently operating in. The Insurrection Act is a statutory exception to the Posse Comitatus Act. So like you say, once it is invoked, the president can use the military for federal law enforcement purposes, right? Now, those purposes are not like general law enforcement purposes. You have to use the military to suppress that riot or insurrection. But it's a little bit circular, right? Because it kind of depends on how broadly you're construing the obstruction to federal authority.
Well, and they're also talking about crime as well.
That's right? So like if you're construing the obstruction of federal authority as like everyday crime that exists in every city over the course of human history, then like the ambit of what you can do is going to be broader in ways that we just frankly have never seen before with prior invocations of the Insurrection Act.
When was the last time the Insurrection Act was invoked?
So last time it was invoked was with the Rodney King riots. Okay. That was at the request of the governor of California, right? So a bit different. The last time that we see the president unilaterally deciding to use the Insurrection Act is in the civil rights era, when you have state governments who are opposing federal judicial orders to integrate schools.
Let's say Trump invokes the Insurrection Act.
Yeah.
What's the process? I mean, It feels like it would make its way up to the Supreme Court, and the Supreme Court is very lenient towards the presidential, executive power.
Yeah. There are a couple of procedural requirements. So the Insurrection Act, the provisions of the Insurrection Act, requires that before you invoke it, you have to first issue like a proclamation to disperse. This is very, remember, folks have to go back to like in the 1800s.
Literally.
Guy
Hear
on a
ye,
bugle.
hear ye.
Seriously, right? You have this, for example, the Insurrection Act is invoked this one time to suppress a strike at a mine in Colorado. And the proclamation is a guy with a bugle coming down the hill before the rest of the cavalry comes behind the guy with the bugle, right?
The good old days.
The good old days. Back when we suppressed labor. So there's something similar that we would expect now, right? So the modern version of this is that the president posts a proclamation on the White House website that tells the rioters to disperse. And then, if, past is prelude, then what we would see after that is an actual invocation of the Insurrection Act as soon as a minute afterwards, right? So LBJ, when he invokes the Insurrection Act, 12:59, proclamation to disperse, 1 o'clock, invocation of the Insurrection Act. So I'd expect that, right? Then, as you say, we will immediately see litigation, right? So the litigation, immediately see litigation. Everyone's preparing for this, right? This is, it's almost been surprising that we haven't seen public discussion of the Insurrection Act sooner.
Well, they're trying
frankly.
to ease our way into it. They're like, we're getting in there.
That's right. Just dipping our toes. So we would immediately see litigation. The litigation is going to focus, I expect, right, on the scope of the president's discretion to determine that there is an obstruction of federal law, right? Because in the past, our circumstances have been, generally speaking, pretty clear-cut. You have a state governor who gets an order from a federal district court to integrate a school, and he says no. That's pretty clearly obstruction of a federal judicial order, right? The facts here are not that. So there's going to be litigation about, what is the scope of the president's discretion? Now, unfortunately for those who, I don't want folks to get too optimistic about the... Are two guys? Do folks get too optimistic about these things? I don't know.
Not in this day and age.
Okay, in case there's one person who wants to be more optimistic, they shouldn't be.
Yeah, ruining that shit. Sorry.
That's right. There are reasonable arguments here, right? I think that we do have to give these terms meaning. But with all of that said, we have at least one case, Martin v. Mott, from a very long time ago, that's about, interpreting the scope of the president's discretion under the Insurrection Act. And the Supreme Court at the time basically said that it's incredibly broad, right? They basically handed the keys for factual determinations over to the president.
I don't love that.
Yeah. And so this case has come up in the California litigation. It's why the Ninth Circuit reversed the district court judge on the LA decision. It's what I expect the Ninth Circuit's going to do again with the Portland decision. There's an incredibly strong presumption in this context for deferring to the president. Again, we're going to see actual litigation with, parties urging the court to give actual meaning to some of these terms. But it's going to be an uphill battle.
So you think if Trump were to invoke the Insurrection Act, there's not really going to be much legally, it's going to make its way all the way up, but you'd be surprised if the Supreme Court were to limit it?
Ultimately, yeah. I wish I had more to say about that. That was better.
I wish I had Bailey's in my fucking coffee.
I know. It's the other things to know for people. This is why. I'll say this perhaps. There were serious attempts to reform the Insurrection Act during the Biden administration, and they all got nowhere. Folks have been eyes wide open about the frailties of this law for a really long time, and that concern has been bipartisan in prior times.
Although Marjorie Taylor Greene, now a bipartisan queen,
this is a fair point.
Knows what's happening?
We fully entered the upside down. I truly don't know what to do with myself.
It's all, no one knows. We're living in a simulation. Nothing's real.
This is correct. Yeah. Yeah.
I want to dive into the concept of plenary authority because Stephen Miller let it slip on CNN. If people haven't seen it, you guys need to go see it. He literally said plenary authority and then froze because someone obviously was in his ear being like, shut the fuck up right now. So let's dive into the statute. What does this really mean?
Yeah. So this plenary authority thing, like in the context of, like, if we're thinking just about using the military in the United States, like this idea that the president has plenary authority, right, to decide when and how to use the military, like, A, is not true, right? Because we have statutory language on this issue that actually gives us a construct, right, for like what facts we need before these statutes can be invoked. And so like the closest analog to this idea of plenary authority would be like actual martial law. But we also have Supreme Court case law about when the president can resort to martial law, and it is not when we are generally in peacetime. So the case that has to do with martial law is from the middle of the Civil War. And there's this argument by the Lincoln administration that literally, right, the military could be used to administer a region in the Union. So this is not part of the Confederacy, in the Union, right? That was like generally close to the battlefront border. And the Supreme Court said no, right? They said the doors to the courthouse are open. You are not behind enemy lines. You could plausibly make a case for the need for martial law. And indeed, martial law was employed like in sections of the Confederacy during the Civil War. But that was like not in the Union, right? We did not have martial law in New York during World War II or World War I. And again, it kind of all goes back to this decision from the Civil War. So the idea that there is this like vat of plenary authority that the president can dip his foot into whenever he pleases is just entirely like anathema to our constitutional tradition.
And how sure are you on that if that were to make its way up to the Supreme Court right now?
So I feel very certain that that one would survive even with this Supreme Court.
That's good.
Okay, right. Yeah. No, like again, it's like it's a low bar. But I feel quite confident about that one. Yeah.
We love that.
Right. That's right. It's a very old it's a very old precedent. If they overturned that precedent, you are basically giving up on the project of constitutional governance. And for as much as the current Supreme Court has ceded a whole heck of a lot to the president, I don't think that a majority of the court would sign on to that.
That's cool. I like that.
There you go.
That's that's a little bit of optimism we're allowed to hold on to.
That's right.
A little bit.
That's right.
I mean, you've studied like domestic military, has the U.S. seen something like this before?
Listen, like U.S. history is long, and there are many parts of it which are quite bad. Actually. So it's hard to say that it's entirely unprecedented, but I think I can say a few things. So one is like in our modern history, and so like if we think of like the time period since World War II, there is no factual situation similar to what we are currently seeing. There are kind of like they're not strictly analogous, but there were lots of really aggressive uses of the military based on inherent presidential authority during World War I, particularly to like suppress labor unrest, out of concern for communist influence, things of that nature. But again, even that was in the midst of World War I, like an actual international armed conflict that the United States was in, which is itself like, distinguishable from where we are currently. It's like you have to reach back really far, right, to find anything even close to the audacity of the arguments that the current administration is making.
Audacity is correct. Like it's the audacity.
Like, if I saw these like assertions on an exam that my students gave me, like they wouldn't do very well, because like it's just so untethered from how we think about emergency powers currently.
What are your thoughts on them declaring Antifa a terrorist organization? What is that teeing them up to do? Because I know there's a long-term play there.
Yeah. So, as folks may know, right? I mean, like legally, there's no there, right?
Antifa, one, is also just means anti-fascism. Okay,
right. So it's like not an organization, right?
And that's all it means.
Right.
There's no like secret like meeting place. It's not like the fucking Freemasons. Okay, like I don't know.
The closest analog I can think of is like it was kind of like the declaration of the war on drugs, right? I mean, like like it's like again like another war on an idea. That I thought was a good one, but anyway, whatever. So I think the way I see this kind of playing into our discussion so far is that, to eventually try to assert powers under the Insurrection Act, or even in the really extreme case, the so-called plenary authorities that Stephen Miller was talking about, you have to create a factual universe of crisis, right? Like, because it's those facts that you need to like substantiate the like really, incredibly broad legal arguments that you're making. And so I see this and, all of the other attempts by the administration to reframe, issues of day-to-day like crime and immigration kind of matters in like a war framework as like shaping that factual universe, right? Because they know that like even though district courts, right, are in the business of making factual determinations, the Supreme Court, which is where all of this is going to end up going all the time, right? These kind of framing maneuvers matter. And so I kind of see it all like as part of a piece of creating a sense of crisis that would justify the really extreme actual legal moves that would come later.
Interesting. Very interesting. I mean, they're rather hysterical, if you ask me. They're really creating crisis out of nothing.
So what was really interesting, so in the...
Maybe they're too emotional to be in office. Putting that out there.
Yesterday we got the temporary restraining order decision from the judge in Chicago, and I thought that her decision from the bench was really fascinating. So if for folks who didn't kind of key in on it, she determined that the use of Section 12406 to federalize the National Guard was unlawful because there was no insurrection or obstruction of the law in Illinois to justify it. And as part of the factual analysis that she was doing orally, she at the end talked about how she just didn't trust the factual representations that DHS was making. And like on the one hand, that might seem really intuitive to like folks at this point, and on the other hand, like from a strictly legal kind of judiciary perspective, it's remarkable, right? Because like at this point, folks may have heard that there's this like really strong presumption of regularity, right? That courts have towards the executive branch, right? It's this really strong presumption that the executive branch is faithfully and accurately conveying facts to the court. And for her to say explicitly that she didn't believe that was true anymore, like upturns the whole apple cart of how the judiciary interacts with the executive branch. And like, again, I think we've seen this implicitly, more or less implicitly, in a whole bunch of other cases leading up to this point. But I think this is the moment that it's most explicitly been called out. And this, I think, is like the actual disagreement that we keep on seeing between district courts and appellate courts, right? Do we actually trust the facts that we're getting from the executive branch? And appellate courts have been much more comfortable in saying yes than the district courts, which are the ones that are actually seeing the facts on the ground.
That's crazy.
Yeah.
My final question is, I mean, Trump had the Texas National Guard go to Illinois, which feels relatively unprecedented.
Yeah.
And a complete violation of state separation authority, you know.
Mm-hmm.
What do you make of that?
Yeah, so this ends up getting very strange very quickly. So there are, generally speaking, two ways that you can take someone who's in the National Guard and give them a federal mission. So the first one was the way that we've been talking about so far. Section 12406 and other statutes like it takes that member of the National Guard from their civilian status and makes them a member of the federal military, right? So even though they're members of the Texas National Guard, right now they respond to the president, right? Their commander-in-chief is the president right now, right? They're just like any other soldier in the Army. There's another statute, Section 502 of Title 32, and it's a really weird one because what it does is it takes, again, a National Guard member and it puts them into a state duty status where they are members of their state militia, responsible to their state governor, and it gives them a federal mission. So they're doing something for the federal government, but they're still members of their state militia and not in the chain of command that goes to the president. It's a really weird hybrid situation. It causes all kinds of problems because it also means that when they're in that duty status, they're not subject to the prohibitions of the Posse Comitatus Act. And so it's often used as an end run around the Posse Comitatus Act. Okay, I say all of this as like prelude because in the years since this statute, Section 502 of Title 32, was enacted, it's been increasingly used for a broader and broader range of operational deployments, some of which have occurred across state borders. The question that we have presented to us now, which we haven't had presented to us before, is whether that deployment is lawful when the governor of the state where they're being deployed to has explicitly rejected that deployment. In the past, we've had instances where like the governor just wasn't asked and there was silence, right? But where you have actual rejection, right? Is that legally significant for all the state sovereignty reasons that you were just talking about, right? We have absolutely no case law on this. I
am so tired of living in unprecedented times.
I know. Give me those precedented times, right? They were great.
Please.
To the extent that that statute is used in the future, that's definitely going to be a key part of the litigation. The administration in this round has gotten around it by using Section 12406, which doesn't pose quite the same questions, right? Because, again, these members are now just members of the federal army, which is why they're being commanded by U.S. Northern Command, right? And so, yeah, it like there are many possible avenues here, and you know, sometimes we see switching between authorities so that they can get around, you know, different injunctions or kind of other practical obstacles, and so I think we'll end up seeing a combination of the two.
Fascinating. Is there anything else you would like to touch on?
This last thing is a hobby horse of mine, and it's great, good. So I've written a decent amount about how, because this area of law is so deeply broken, one of the most important restraints on the president has actually been appropriations law, like the amount of money that is given to the Defense Department, because like all of these things are just incredibly expensive, right? Like it's hard to fully wrap your mind around how expensive these things are. All of these members of the National Guard who are now on these 12406 orders, they're getting like federal salary, they're getting federal benefits, they're getting their pension. Like these things balloon in cost incredibly quickly. And most of the time, they're not appropriated in the yearly appropriation, which means that the Defense Department has to come back to Congress asking for more money.
Please, sir, may I have some more?
That's right, literally, right? Otherwise, they have to shift money around internally, and they're limited in how much shifting around they can do. And that starts to have readiness implications for the Defense Department's like actual outward facing missions. And so I used to be really bullish on the fact that, like, you know, appropriations law was like a really important way for the Congress to like really meaningfully restrict what we're seeing here. And so I think actually the fact that we see Congress totally abdicating its role in kind of the appropriations world, and second, the Supreme Court acquiescing in these like incredibly aggressive moves by the executive branch to assert powers that they just don't have in the appropriations world, like, is really meaningful in this context, because it has been one of the more meaningful tools for limiting what the president felt he's been practically able to do with the military in the United States.
Interesting. That's, once again, a bummer.
Yeah, I know. I presented a paper to my colleagues on the faculty recently, and then one of my colleagues said this was the most depressing paper he's ever read. And said, welcome to my scholarship.
So exciting. You're like, guys, I'm going to ruin your day again.
That's right. But please enjoy the lunch.
Yeah, literally. Well, Chris, it has been lovely to have you.
Thank you very
so much
much
for doing this.
Of course.
And I'm your host, Emily Griss. We'll be back next week with another episode of Bureaucracy.